Right, good morning, Councillor Udy. The live stream has started.
Over to you, Ben.
Good morning, everybody. Welcome to this morning's subcommittee. I'm sorry, Chair, you have to forgive me. I don't have the script in front of me, so I'm going to just do this off the bat, so to speak. My name is Ben Attrell. I'm a solicitor employed by Portsmouth City Council. Do we have our three members present today?
Oh, Dave's still not got his video feed on, so I don't know if he's here or not.
I should have it on.
I can't see it. Oh, there you go. Hey.
I'm here.
Marvellous. So, are there any declarations of interest for members this morning? No? Marvellous.
You're supposed to nominate me as chair, Ben.
Oh, apologies, Chair. Councillor Udy, I'm presuming you're going to be taking the reins as chair this morning. Do we have a nomination for that, please? Members on the subcommittee? Yep.
Yep.
And is that seconded? Yep.
Sorry.
Fair enough. Marvellous. Thank you. So I hand over to you, Chair, to take over the meeting. Thank you.
Thank you, Ben. Good morning, everyone. I'm Councillor Udy, UT. I can say my surname now. And welcome to the Licensing Subcommittee committee. This meeting is broadcast live to enable the press and public to view the meeting. We are currently meeting virtually in response to the limitations placed on government by the COVID-19 pandemic. Until recently, the law generally stated that all members had to be present in the room to make formal decisions at meetings, although it was arguable that this did not apply to licensing committee hearings under the Licensing Act 2003. However, in any event, the law was amended in response to the COVID-19 emergency, and councils are now able to hold all public meetings virtually. For the purposes of this meeting, and having been advised by the City Solicitor, I can confirm that the hearing shall be run pursuant to Section 78 of the Coronavirus Act 2020, regulations made thereunder, and the Licensing Act 2003, regulations 2005, which enable the authority to establish its own procedure. Members are reminded to be available throughout the meeting and indicate if they need to leave the proceedings at any point. All three members must be present at all times to be quorate. If any of the evidence is missed by any of the members due to connectivity or other issues, please raise the matter as soon as possible so that it can be addressed. Sorry, I just lost my page. Members, officers and participants are requested to keep their microphones on mute and only turn these on when they are called to speak. This will limit the amount of background noise, which can be very disruptive. Members of the committee who wish to use the chat facility can simply write their name. Please do not use the chat facility for anything else except to raise a point of order. If there are any technical difficulties, we will endeavour to resolve these and when necessary have a brief adjournment, but the meeting can proceed where quorate. I will now explain the running order for this meeting. Members will first declare any interests. The licensing officer will present the report. The members, the applicant or his solicitor may then ask questions of the licensing in that order. The applicant will then present his case and questions may be asked of the applicant. Finally, everyone will have the opportunity to sum up their case. In my wording, there's missing of deputations here. So after the applicant has summed up their case, questions may be asked of them, and this is I'm gonna start this again because it was missing the people that have raised representations against this in my script. So number one, the licensing officer will present the report. The members, the applicant or his solicitor, and the people that are here to give deputations today may then ask questions of the licensing officer in that order. The applicant will present his case and questions may be asked of the applicant in the order I said, members first, and then people that have given deputations will be able to state their case following the representation that they have sent in during the period. Then everyone will be able to sum up their case, starting with the applicant and then the licensing officer and then the people that gave representations, am I right? And then the meeting will end. Members will meet privately for deliberations and reach our decision, which will be circulated to all parties as soon as possible. To reiterate, each party will have an opportunity to ask questions at the appropriate time and to make their own representation when asked to do so. Parties are reminded that representations are strictly limited to only those points that are raised in your respective written representations. You are able to expand upon these points but not add new. You can be assured that members have read the papers before, and as a result you are not asked to simply read your written representation. Right then, I'm sorry that that was a little bit was missing out of my script, but I'm hoping that it's all clear for you. I'd like to do introductions now. I would like to invite the members to introduce themselves. I will read your names out in alphabetical order. Please can you reply by stating your name and saying you're present. I will pause for a few seconds between calling each member. I call Councillor David Ashmore.
Councillor Dave Ashmore, present.
Thank you. And Councillor Linda Symes.
Councillor Linda Symes, present.
Thank you very much. Can I now ask the following officers to confirm they are present as follows? Ben Attrell, Legal Advisor.
Ben Attrell, solicitor employed by Portsmouth City Council, present. Thank you.
Thank you very much. Derek Stone, Principal Licensing Officer.
Good morning, members. Derek Stone, present.
Thank you. Anna Martin, Local Democracy Officer.
Anna Martin, Local Democracy Officer, present.
Thank you. I now ask the following if they are present. Mr. John Walsgrove, Solicitor for the applicant.
Good morning, John Walsgrove, present.
Hello. Mr. Steve Hudson, Operations Manager for the applicant.
Hello, Steve Hudson is present, thank you.
Hello, good morning.
Morning.
Mr. Dewhurst.
Yeah, I'm present.
Thank you very much. Mr. Owens.
Yeah, good morning, Jeremy Owens, I'm present.
Thank you. Mr. Spraggs.
Yes, good morning, Andrew Spraggs, present.
Thank you. And Mr. Yates.
Yeah, good morning, Anthony Yates, present.
Thank you very much. Ben covered this very briefly at the beginning, but I'll do it again. I will move on to declarations of interest. Do any members have any declarations that they would like to make? Councillor Ashmore?
No.
Councillor Symes?
No.
Thank you. I have no interest either. I will now move to agenda item 3 to consider the application for a premises licence, the Wellington and 62 High Street, Portsmouth, PO1 2LY. Mr. Stone, Principal Licensing Officer, please present your report.
Good morning, members. This hearing is in relation to an application for the Wellington Public House, as you said, 62 High Street, Old Portsmouth. Members, you have my report before you, so I will not go through that in detail, but will summarise the situation and how this matter has come before you today. The application is made by TW Assets Limited. The Wellington pub is one of the oldest pubs in Old Portsmouth, and it was registered as the Wellington Tavern from a record I have seen as early as 1859, although I believe the pub to be much older than that. The previous premises licence was in the name of Wellington RITS Limited, and the director was a Mrs. Lorraine Lum. Wellington Ritz Limited became insolvent and was dissolved on the 10th of March 2020. Under Section 27 of the Licensing Act 2003, where a premises becomes insolvent, the premises licence lapses with immediate effect. If action is taken within 28 days, then the premises licence can be reinstated with minimal delay and expense under Section 50 of the Act. Members, I'm sure you need no reminding that around this time in March, due to the global pandemic, all pubs, bars, restaurants and many businesses were forced to close, with pubs and bars remaining closed until the 4th of July. Only when the Wellington reopened and the application was made to transfer the premises licence over into the new owner's name was it discovered that the premises licence had now lapsed. Had that not happened, the licence would have been changed in name with no alteration to any of the licence or the existing licence conditions attached to the licence. And members, you have a copy of the old premises licence at Appendix E in your bundle. As a result, a new application was submitted and the premises had to rely on temporary event notices to continue with limited trading days, pending either the automatic grant of the licence as applied for, or subject to valid representations, pending the outcome of a licensing subcommittee, which is how we are here today. The reason why we're here is because we have 4 valid representations which have been received from Mr Spraggs, Mr Dewhurst and Mr Yates, who live very close to the premises, and also from Mr Owen, who lives nearby. Members, you have those reps before you at Appendix C, so I will not repeat them. As you know, they're all present today and will address you in due course. Members, the applicant has detailed in the operating schedule the steps they intend to support and promote the licensing objectives. These include all windows should be kept closed whenever the premise is open to the public, and the licence holder taking such steps as are reasonable to recognise the rights of local residents and to encourage customers to leave quietly. Additionally, the applicant has agreed with the police a number of conditions with regard to CCTV, staff training, refusal logs and Challenge 25 procedures, with proof of ID for anyone under 25. You will see from the representation of Mr Spraggs that there's been some history over the years with environmental health and their engagement with the premises over reported issues. Without going into too much detail, I think it's fair to say that the previous dedicated premises supervisor perhaps did not help by failing to address these issues, and at one point in 2010 a noise abatement notice was issued at the premises in relation to noise in the rear garden and courtyard area, restricting its use after 10 o'clock at night. For reference, members, that DPS left the business in January 2019. You will see in Appendix D, Mike Thorne from Environmental Health has recently engaged with the premises, and an agreement has been reached with the applicant that the garden area or courtyard at the rear will not be used between 10 o'clock at night and 9 o'clock in the morning. Additionally, they have agreed to limit the noise from a compressor to an agreed level. Despite all these assurances and undertakings, those making representations still wanted the licensing committee to continue. Members, a matter that is still of concern is the extractor fan, which you will hear mention of, and Mr Walsgrove will advise you regarding this and how, in his view, this is not a matter for you to consider under this hearing. However, I can inform you that Environmental Health are still engaged with the applicant regarding this extractor fan. I have seen email exchanges between Environmental Health and Mr Walsgrove, and this is work in progress to resolve. The applicant complied with the necessary provisions contained within Part 3 of the Licensing Act by way of public and press notification, and local ward councillors were notified. Members, you are required to determine this application once you've heard from all parties, and I've listed in my report at paragraph 5 what you must have regard to, the first and foremost being the promotion of the 4 licensing objectives. In my report, I hope I've given you some helpful guidance which will assist you in reaching your decision. I have advised Mr Spraggs, Mr Dewhurst and Mr Yates that, as in all licensing applications that go before a licensing subcommittee, that I draw your attention specifically to paragraph 11.1 and 11.2, which deals with the review of premises licence as a key protection for the community where problems associated with the licensing objectives occur after the grant or variation of a premises licence, and how that licence can be reviewed should that be necessary, together with what sanctions can be applied for and a review hearing. Members, I don't propose to say any more at this stage. I'm obviously available during the course of the hearing for any questions as they come up. So if I can assist you any further, I will. Thank you.
Thank you very much, Derek. Members, do we have any questions? I'll start with you, Councillor Ashmore.
Not at the moment, no.
Councillor Symes, do you have any questions at all?
Not at the moment, no.
I don't have any at this moment. I think I'm going to ask some more later. I guess it's more when the representations come in that I may ask the questions. Do you have any questions, Mr Walsgrove?
No, thank you, Chair.
Thank you. I shall move on to Mr. Hudson. Sorry, I'm on the script. Mr. Hudson, do you have any questions of the officer at all?
No, I have no questions. Thank you.
Thank you. Mr. Dewhurst, do you have any questions?
Not at the moment, thank you.
Okay, thank you. Same again for Mr. Owens.
Yeah, I do have one. Mr. Stone, you touched very briefly on police conditions. I don't think they're written down anywhere in the bundle that has gone out. Can you expand on those a little bit?
So I missed the question. Can you say again?
Yeah, I said you touched very briefly on police conditions. I don't think they're written down anywhere in the bundle of papers that we have. Can you expand on them a little bit?
Yeah, I can tell you the agreed conditions. They've agreed to conditions in relation to CCTV, the production of CCTV to the police. They've agreed to staff training. They will have a refusal log. They will adopt the Challenge 25 procedure and proof of ID. It's the normal conditions that police ask of nearly all venues in Portsmouth to comply with, and they've happily agreed to comply with that.
Okay, yeah, thank you very much. That's very helpful.
Thank you there. Mr. Spraggs, do you have any questions?
I don't, thank you.
Thank you. And Mr. Yates?
No questions at the moment, thank you.
Thank you. If there's no further questions for Derek, we will move, Mr. Stone, we will move on to the applicant's case. So, Mr. Walsgrove, could you please present your case? Thank you.
Thank you, Chair. As you heard from Mr. Stone, the Wellington is a very old pub, earliest records dating back to the 1850s, and obviously this public house has been there long before many of the residential properties were built around it. It is a difficult decision you've got because, of course, wherever licensed premises sit cheek in jowl with residents, there is a balancing exercise to do to ensure that both the premises can trade and have a successful business, but also that the residents have a reasonable, peaceful enjoyment of their properties. And what we're not saying is that there hasn't been a history of issues at the premises, and simply we just don't know. I can't comment on any of the history or any of the comments that have been put forward by residents prior to the premises reopening in July of this year, because that was under a different premises licence holder and DPS at the premises and ownership. So whilst we have every sympathy if those issues have arisen, we want to reassure the committee and those residents who are here that the premises will not be managed in that way. It will be managed professionally, and some of the issues that have been raised have already been addressed and will be addressed shortly, and I'll come on to that in a moment. If I could just draw your attention to page 31 of your agenda papers, that shows the plan of the Wellington. You may be familiar with the premises in any event, but you can see from that plan that in fact the premises is a pretty small establishment and has up to about 50 seats around tables and chairs. It's not a large venue, and it's certainly not what you might describe as a vertical drinking establishment. This is not about people coming in, cramming the place and trying to drink as much as they can through the week and on a Friday and Saturday night. It does do a good food offer, and that is one of the mainstays of the business. It actually attracts a good mix of the local community, residents of the immediate vicinity, but further afield into Portsmouth. The applicant, as you've heard, TJ Events Limited, that is operated by Tommy Ware. I'm sure you're familiar with Mr. Ware. He refurbished and reopened the pier. He's an experienced licensed operator within Portsmouth, and this morning you've met Steve Hudson, who's a consultant to Mr. Ware, and he too is a very experienced Portsmouth licensee, has run several establishments in Portsmouth. So you've got a good team behind this new venture. Just coming round to the application, obviously you've heard from Mr. Stone that in fact what should have happened was a simple transfer of this premises licence. Regrettably, the former premises licence holder's company became insolvent, and that automatically lapsed the premises licence. What could have happened was a simple transfer within that 28-day statutory period to bring the licence back to life. And on a transfer of a premises licence, the only party able to object to a transfer are the police, and they are only able to object on the grounds of crime and disorder, prevention of crime and disorder, and notably none of the residents have raised issues of crime and disorder. Their representations are about public nuisance. You've heard the reasons explained why that didn't happen. Obviously the premises shut due to the COVID situation, and regrettably the transfer then was not submitted in the relevant time, as every member of staff within the applicant's organisation were furloughed, and then on reopening the premises, that's when it came to light, when the transfer was submitted, that it was too late and a new licence would have to be applied for. Now the application itself is for the same licensable activities and for the same hours as the old licence. The difference is this licence will be better regulated. It's been modernised, if you like, with the agreement of conditions with the police, but also we included in the operating schedule those enforceable conditions on the old licence to go on the new licence. There were one or two conditions on that old licence which, in my view, were unenforceable, and therefore there wasn't any point in putting them forward in an application. Obviously, we've become much more astute in writing enforceable conditions. So you may see a slight difference from the conditions proposed in the application to those on the existing licence, which is also in your pack. What I will say is conditions have been agreed with the police, which Mr. Stone has outlined for you, and also with environmental health, and that the two conditions there are set out on page 5 at paragraph 4 of your committee papers. The principal condition that the environmental health officer was keen to discuss was the use of the rear garden. You heard from Mr. Stone that there was an abatement notice served on the last but one premises licence holder, and that abatement notice required that person to abate the noise from the from the garden, and of course that abatement notice would not be enforceable against my client for the new premises licence. So the environmental health team were keen to ensure that the garden was only operated until 10 p.m. In line with that former abatement notice, and my clients have agreed that, and we say that is a significant concession on behalf of the applicant. Just summing up around the environmental health officer and police officer's conditions, obviously they have not made a representation on the basis of that agreement. And I know you, as an experienced licensing committee, will be aware of the guidance issued by the Secretary of State under Section 182. But for the sake of the residents who are at this meeting, I just want to draw their attention that that guidance would suggest to a licensing committee that in terms of crime and disorder, certainly the police would be the first source of advice that you would take on board, and likewise for public nuisance, for environmental health. So the responsible authorities are clearly experts in their field, and I suggest you should attach considerable weight to the fact that the conditions agreed with those bodies are sufficient to meet concerns raised in this application. You have heard that once it was discovered the licence had lapsed, the premises then applied for temporary event notices for weekends through the end of July through into August. And the premises have not received any concerns or negative feedback from any of the responsible authorities, nor indeed have they had any concerns raised by local residents directly with the premises, other, of course, than the representations which you have before you today. What I would refer you to now is page 7 of your committee papers, and Mr. Stone has summarised some of the paragraphs of the section 182 guidance, but in particular I draw your attention to paragraph 9.43, which is on page 7, and it says a licensing committee's decision should be evidence-based. And that's important because I would respectfully submit to you that everything I've said thus far is credible evidence on which you could base a decision to grant the new licence and have confidence that the licensing objectives would be promoted, and that in balancing the needs of both the residents and the licence holder, should you grant the licence, that the activities, hours and conditions applied for are perfectly reasonable. Turning specifically to the residents' concerns, the first one I'd like to deal with is the issue of the extraction and the food odours. Now, the premises has not applied for late night refreshment. Late night refreshment wasn't on the previous licence. So if you didn't grant this application, if you didn't grant the licence, the premises could still trade. It would be able to provide food and obviously soft drinks, and in fact people would be able to bring their own alcohol to drink at the premises with that food. So the first point to make on that is it's far better to allow people to consume alcohol under the regulation of a premises licence than it is to let people bring their own alcohol to a premises. But secondly, the provision of food is not a licensable activity, and therefore my submission is that no condition should be added to this licence regarding those food odours or extraction. And your environmental health officer in fact agreed with me that a condition should not be put on the licence, which is why he has not asked for any condition. You did hear from Mr. Stone, however, that the discussions with environmental health are ongoing, because of course it's creating a nuisance which, under the Environmental Protection Act, the local authority have sufficient powers to deal with. They could issue an abatement notice in relation to that extraction system. So they have sufficient powers to deal with this issue. But of course, my clients are working towards a solution with environmental health. They already have had workmen on site to provide a quote in relation to sorting out that issue. And that will be done as soon as reasonably practicable. So whilst I'm saying it's not relevant to today's application, I do wish to reassure the residents and the licensing committee that my client is not simply ignoring that issue and will be dealing with it and will continue to liaise with your environmental health department. Secondly, in the representations, there's a lot of comments regarding the history of the issues. And I've already made the point that, in my view, those would not be relevant to the new management of these premises. And unfortunately, we're not in a position to comment on them as to whether they are credible or not. But what I would say is you can have confidence in this new management team under Mr. Ware and Hudson's leadership, that any of those issues before are not going to arise in the future. Obviously, one of the historical issues is the condenser, and that issue we say has been adequately dealt with the condition agreed with environmental health, a copy of which is in your agenda, and we say that is all that is required in relation to promoting the licensing objectives in relation to the noise nuisance from the condenser. The third matter raised, which I've already mentioned, was the garden, and again I say that the condition agreed with environmental health to limit its use between 9 AM in the morning and 10 at night is perfectly reasonable and a balance between the commercial properties and residential properties. And then lastly, the issue of the waste has been raised, and again I say that those are historical issues. There's photographic evidence in the representations of rubbish outside the premises, but notably none of those are of the current premises, and you'll see in fact the colour of the paint on the premises are all different colours, and so they must have been taken over some period of years. And I would say that again is not something which you should consider today in relation to applying a condition to the premises licence. In an attempt to avoid this hearing, the applicant did offer to impose conditions on the premises licence, but as we are here and the hearing could not be avoided, the conditions regarding the waste are not offered. Obviously, it's a matter for the committee whether you choose to impose a condition regarding waste if you grant the licence, but I would say that in fact there isn't credible evidence to say that the current management of the Wellington, if you granted the licence, would cause any such nuisance. And of course the Environmental Health Officer again has not asked for any condition regarding waste. So the current management have a contract with a company to collect the waste. There's 2 collections each week on a Tuesday and Friday. The waste will be in the wheelie bins. There is a storage area at the back of the premises, a bin store. So once they will be put out on the Tuesday and Friday morning, once they've been collected, they will be immediately returned to that bin store area. So, as I say, I would say it's not right to look at imposing any condition there based on the historical evidence of poor management from previous owners. I do know from one of the objections, concern was raised about noise in the early hours of the morning, reference to some males and females. That was a member of staff. The management of the premises were aware that that member of staff had returned to the premises. It was closed. It wasn't open to the public. They should not have been there, and because of that gross misconduct, they have been dismissed from the property. So in terms of the issues raised, it is accepted that there were people at the premises later than the opening hours. It wasn't open to the public. It was a member of staff, and they did the appropriate thing and dismissed that member of staff. So just in summing up, on the basis of the operation of the premises under temporary event notices and the previous experience of the management team, I would invite you to grant the licence as we've applied for, with the conditions agreed with the police and with the conditions agreed with the environmental health, safe in the knowledge that should there be any issues in the future, then any of the residents or any of the responsible authorities can then bring a review, which is a quick and simple process to bring the matter back before a licensing committee to then consider what appropriate action they should take. So councillors, that's the representations on behalf of the applicant, but of course if you have any questions I'll only be too happy to answer them.
Thank you, Mr. Walsgrove. I'd like to open up for questions from members. Councillor Ashmore or Councillor Symes, do you have any questions?
No, not at the moment.
Jigs. You covered the 10s, which I'd like to have asked about, because you've had that during the period that you've been reopened. So I don't think I have any questions at the moment. You've covered about the incident where with the potentially Class A drugs. I'll have to move on to Mr. Stone. Do you have any questions at all of the applicant? Are you there? Rocky, do you have any questions? So I saw you said no, but you marked yourself. That's fine. I'd like to move to just looking at the order of people in. Mr. Dewhurst, do you have any questions of the applicant at all?
Yes, I do actually.
Yeah, go ahead.
In relation to the rubbish, the colour of the facade of the property has changed 3 times within the last month. So I'd just like to state that whilst it's been under the ownership or control of Tommy Ware, the colour has changed 3 times. And so I have evidence of rubbish out there over the last month. In fact, there have been wheelie bins out there all this week. I also contacted the council in July to say that...
Is this a question of Mr. Allsgrove, please? Could you frame it as a question? Sorry.
I would like to say that I contacted Portsmouth City Council to say there was a problem with the rubbish. So please, can you tell me how you feel there is not a problem with the rubbish at the moment and that it shouldn't be taken into account, bearing in mind that you actually offered it up as a condition and for some reason decided to remove it?
The offer of the condition was in an attempt to avoid a committee hearing because obviously my clients wanted the premises licence as soon as they possibly could. It's common in negotiations with either responsible authorities or residents to offer conditions as part of a mediation process, but on the basis that if those can't be agreed, then the matter goes to the committee and the committee determine what the appropriate conditions are. And that's exactly what I explained when writing to you all, to say that those conditions were only offered on the basis that you withdrew your representations, and that in fact all 4 of you withdrew your objections, otherwise those conditions would not be agreed. So that's that position. In relation to the management of the waste, I've set out what my client has said they are doing and the contract they've got with the company to collect waste on Tuesdays and Fridays, and that waste will only be put out for collection on those days.
Thank you. Do you have anything to add? Yeah.
Yes. In that case, can you please tell me why you think that the conditions that you were willing to impose or to apply to the licence don't apply anymore, bearing in mind that rubbish management has been absolutely terrible over the last month or so, and I've still been suffering from problems. For example, on the hottest day of the year, there were 8 sacks outside dribbling with mess, and I have photographs of them, more evidence, which I could present. I haven't presented, but it's clear there is a problem, and this is under the new management, not the old management. This is under the new management. So therefore, I really feel that a condition should be applied to ensure that we don't keep having this recurrent problem, regardless of whether rubbish is collected twice a week, because it always has been, supposedly, but the problem still remains.
I'm not sure what the question was there, but in response to that statement, I can only take instructions from my client on the evidence that's been adduced. I wasn't aware that there had been evidence within the representations about any recent issues. All I can do is reassure you and the committee that that's the commitment my client has given in this meeting, that it's collected on 2 days, that the waste will be within the bins, and that those bins will be removed after collection and returned to the bin store.
Mr. Dewhurst, do you have anything else to say?
So you can assure me that the rubbish has been perfectly managed over the last month? Or please, can you assure me that the rubbish has been managed or hasn't been managed over the last month? Are your clients confident that they have been managing the rubbish well already?
If there were specific days of the week over the since reopening in July where you're saying that hasn't happened, those should have been adduced to allow us to make a proper investigation. So yes, I'm saying my client's instructions are that the waste has been properly managed, and that's as far as we can take the matter today.
Thank you. Mr. Dewhurst, do you have any other questions?
No further questions at the moment, thanks.
Thank you. Mr. Owens, do you have any questions?
Yes, I would like to say that I personally have seen bins outside the Wellington over the last couple of weeks, several bins at one time, which remained outside for 2-3 days at least. There is a bin, or at least there was up until last night, and I suspect it's still there. There was a bin outside which had been there for several days, 4 or 5 days, a blue bin, filthy at the bottom, and full of bottles and glasses.
Are you leaning towards a question at all?
Yes.
You can sum up at the end.
Yeah.
Sorry.
Is Mr. Walsgrove, is he aware of that?
No, I'm not aware of it. As I said, any allegations of issues around noise or waste which were not included in your representations, of course, I have not taken instructions on. I can only deal with what you have put in your representations.
Well, yes, but the detail, this is recent detail, this is recent evidence of the matters that are in the representations. And surely Mr. Hudson is there. Presumably he is possible to take instructions from him now, or perhaps he could comment on it.
Mr. Hudson, you are able to answer at this point if it makes things a lot easier. Thank you.
I can deal with that point. In the licensing committee's hearing, you are not allowed to introduce new evidence because, of course, that puts us at a disadvantage because we're not able to investigate and provide proper answers to your questions. I've explained the procedure. Had you had complaints about noise or rubbish since writing your representation, you could have raised those directly with the owner, which you haven't done, or you could have raised them with Environmental Health, and they certainly haven't said they've received any complaints and passed those on to us. So we can't deal with it, I'm afraid, and I don't want Mr. Hudson to answer questions about information which is only just given to him in a hearing.
Could I ask a question of you, Mr. Walsgrove, please? Where are you? I'm looking at your site map at the moment, your floor plan. Where are your bins normally stored? Are they stored at the back and brought through the pub, or do they only have to be stored at the front because there's no opportunity for anywhere else for them to be?
Mr. Hudson will have to answer your question regarding where the bin store is, I'm afraid. So, Steve, can you explain by reference to the plan?
Yeah, so the bin stores are out the back on the side of the kitchen.
Okay.
Yeah, so it's the top of the garden. It's the top left-hand corner. There's an enclosed space there, and then they're brought out the night before, placed on the street.
Thank you. Yeah, the site plan kind of fades out right at the end, so I was trying to tell, but thank you for clarifying that. Mr. Owens, did you have any other questions at all before we go back to Mrs. Spraggs? Go to Mrs. Spraggs.
Yeah, I do. I don't accept Mr. Walsgrove's way of dealing with that question. If he looks at my representation, which is very brief, on page 47 of the bundle, it says, I have frequently seen large overflowing wheelie bins and sometimes split refuse sacks, etc. The Wellington's arrangements for refuse are inadequate and detrimental to the area generally. So that is a broad statement about what the state of play is with regard to refuse outside the Wellington. I don't put any time limits on it. I think the evidence of what has happened over the past couple of weeks is perfectly relevant and covered by that representation.
Thank you. I'm just going to get our licensing solicitor, Ben Actual, to answer this. Thank you. You there, Ben? Unmute yourself. Oh, sorry.
Okay, I think I'm on now. Sorry, things are a bit slow. It's just taking a few seconds to kick in. My apologies, Chair. Yeah, I was just going to make the point that the issue of waste has been raised in written representations, and parties are enabled to expand upon their representations during the course of the hearing. I think, Chair, it's your discretion, but I think it would be appropriate for you to hear from Mr. Hudson as to what the position is, if you're going to make a proper determination as to whether or not you feel it's necessary to impose a condition requiring any particular action.
Thank you. Yeah, I did make that suggestion that we should hear from Mr. Hudson, only because someone with first-hand experience of the rubbish going out would be more than plausible. Would members agree on that situation? I see you nodding, Councillor Symes. If possible, Mr. Hudson, I'd like you to answer. Thank you.
What was the question you would like him to answer?
Mr. Owens, it's more about the rubbish in the last month.
Yes, over the last couple of weeks, does he accept that bins have been left out, more than one, or say 2 or 3 bins at some stage for more than a couple of days, and in particular that there's been a blue bin full of glasses, bottles, that's been outside for several days now?
Mr. Hudson, are you aware of this? That's probably the most apt question.
Hi, yes, sorry. There has been a couple of issues with the bank holiday and obviously with the lockdown and a significant drop in service, but we're not aware of anything being out for several days, for sure. I know that there was a blue bin that wasn't brought back in, which had some glass in, which is now back inside and in its proper place. But it is Wednesday today, and the collection day was yesterday. But there was an issue, I think, with one of the collections.
Thank you. Mr. Owens, I'm keen to move on to Mr. Spraggs, if possible, because I think we might be recycling. I didn't mean to make a pun then, to be going over the same information. So any other questions, Mr. Owens?
I have got one brief question for Mr. Walsgrove. He said at one stage, he explained when writing to us all various matters. I would like to comment that I have received nothing from Mr. Walsgrove at all. Does he accept that he didn't send anything to me? So I've had no communication from Mr. Walsgrove whatsoever.
I would have to go back and check the email that I sent out. I certainly included you, but maybe the email address was typed incorrectly. So if you had not received an email from me setting out the conditions which we were offering, then I can only apologise for that. Obviously, we're on a live link and I can't make that check. But if you're saying you didn't get the email, then clearly something must have gone wrong with that. So I can only apologise.
Yeah, okay, well, thank you for that. I have subsequently seen the email, and I note that curiously, although it forms part of the story, it's not included in the bundle. Is there any reason for that?
That might be a question of Mr. Stone, perhaps. Rocky? If you're there? Maybe? Derek, are you there?
Yeah, sorry, Claire.
Oh.
You keep dropping out, but I'm listening to on an earpiece and it's slightly behind. So,
Okay.
What was the question?
Mr. Owens asked about the conditions that were sent to the residents. Why wasn't that featured in the bundle pack?
Yeah, what's the question again? Sorry.
Well, it referred to an email from Mr. Walsgrove, which actually said it was sent out to all 4 representatives. I pointed out that I never received it. I have subsequently seen it, but I noticed that it's not been included in the bundle, although it forms part of the very, very much part of the story here. I wondered why it hadn't been included.
I can't comment on that, Chair, unfortunately. It would have been sent out from the office. It wasn't down to me to send out, so I can't answer that. I apologise.
Ben, can I just take some advice from you regarding this? Because I feel like it might be something that we'd want to see.
Yes, I can't see there's any particular issue unless Mr. Walsgrove has an objection to the subcommittee seeing. Oh, clearly all the other parties have seen this document with proposed conditions in order to mediate. And I think as long as the subcommittee understands the nature of the document and the reason why it was drafted in the terms that it was, i.e. in order to try and mediate and settle the matter without the necessity for a hearing, and considers it in that manner, then the subcommittee ought to be able to see it. But unless Mr. Walsgrove has any specific objection.
I don't have any objection, just a question of how we sort that out, really.
If you email it to the 3 councillors, I think we all have access to our emails, is that right? I definitely have access to mine here. Do you, Councillor Symes? Yeah. Councillor Ashmore, do you have access to your email?
I do.
We can keep the stream going and we can take like a 5-minute adjournment just to read the email very quickly. Is that an agreement right now? If you're able to send it out quickly?
It'll take me a little longer than 5 minutes because I have to log into all my records are on the computer. I don't have any paper records, so I need to find the email. And as you can imagine, in this case, there were a good couple of hundred emails. But I can find it and I can send it, but it may take 5 minutes or so just to send it.
Mr. Stone, do you have access to it? Would you be able to email it round quicker, or would you perhaps be able to read out the conditions that were put forward? Is that
I can probably find it within 5 minutes, and it'll be helpful if I can log off and log back on again, because I keep losing your voices and what's being said. So give me 5 minutes and I'll send it round to the councillors.
Okay, perfect. So shall we say 10 minutes adjournment then, perhaps?
Sorry.
10 minutes, sure. Councillor Symes just wants to...
No, that's great. I need to get my computer's running low, so that's
okay.
good.
That's fine. Could you CC in Ben Attrell in that email as well? Just to say that the live stream is still running, so everyone please be on mute, or maybe you're allowed to turn off your cameras during adjournment, but please be aware. 10 minutes, what are we on? 10:50, 11 o'clock. We'll be back with cameras on. Thank you.
Perfect.
Well, I'll see if I can put up the adjournment slide.
Thanks for that. Hi there, it's Councillor Udy. I'm still awaiting an email, so I'm happy to hold the of German until we see some form of email, and then we'll go back to the meeting. Is that fine? I can see some people in the meeting. Are you nodding, Ben? Is that cool? Cool, thank you.
Councillor Udy, I did find the email and I forwarded it to Derek, so hopefully you should have it to forward on to you.
Thank you.
Okay, you should have the email to you very shortly.
I've got it, thank you.
Likewise, I've got it now. I'm reading through it. Thank you.
Councillor Udy here, I can confirm that I've read the email. So when Councillor Symes and Ashmore have done the same, I'm happy to resume the meeting.
Yes, I've read it.
Yeah.
Thank you. Let me just try and work out where we were in the meeting, because if you'd like to ask questions now of the applicant, I guess that's the way around it.
Excuse me, sorry, Councillor Udy, is the adjournment officially finished?
We're going to finish it now, yeah. So if you could take the slide away, that would be very nice. Thank you. Hello, I need to turn my camera on. That would help, wouldn't it? Hello, thank you for bearing with us for that short adjournment. I can confirm that all councillors have now read that email. Councillor, I'm just going to go back to members quickly. Members, do you have any questions of the applicant at all now that you've read that email?
Only really that I can't understand why he wouldn't want to keep those conditions, because they seems that it would ameliorate the situation for the residents in some ways. And it seems most of the suggestions in there seem very sensible.
I might be inclined to agree with you there, Councillor Symes, but I guess it will go into our deliberations later. Other than that, I'm going to return to you, Mr. Owens, because of this email. Do you have any questions of the applicant? Oh, you're on mute, sir. Sorry. Hello.
No, I think I've made the point, safe to say that what Councillor Symes just said seems eminently sensible.
Thank you. Mr. Spraggs, do you have any questions?
Well, I don't have any questions, but we didn't receive a bundle. That's news to us. Who was to send it? Was it Mr. Woolsgrove?
So the bundle, as it were, was the licensing pack that is the reports that come out when a meeting is convened. So it is publicly accessible through the council's website. As far as I know, if you were someone who made a representation, you probably would have received an email saying that the reports for the meeting are out. Mr. Stone is nodding there. So we do all have access to this through the council's website, through the subcommittee page.
Okay. Well, we just weren't aware of it. But thank you for letting me know. We'll try and find it if we received it. Yeah.
It's easy. If you Google Portsmouth Licensing Subcommittee, it's pretty easy to find from that moment.
Okay.
I can assure you that we all have that. It's just the only question that we had is the email that you were sent from Mr. Woolsgrove wasn't in the pack, and we felt the need as members to see that specific email at the time. Mr. Yates, do you have any questions of the applicant?
Well, I'd like to ask Mr. Woolsgrove if he's aware of any connection between the previous licence holder and the current applicant, because I'm not convinced that there is a change in the controlling interest in this licence application. This was suggested in an email from John Woolsgrove in paragraph 2. He says, my client acquired the premises a few months ago. It's actually 1 year and 4 months ago. And this covers the entire period of the main disturbances that we've all put up with. A search of the public record of Companies House indicates a very strong connection with TW Assets and the RITS, as mentioned in Wellington RITS Limited of the lapsed licence. And I feel that a simple reinstatement of the licence as is means that we would be in for the same living conditions that we've had to put up with for the last 2 years, and it's not acceptable. So is Mr. Woolsgrove aware of any direct connection or any connection? Because as I say, you do a search on Companies House and there are quite a few.
Mr. Woolsgrove, thank you.
There's no connection with the previous licence holder. The premises for the last licence holder, Karen Lum, was sublet to her. So she was responsible for the premises and for the management of those premises. Mr. Ware and TW Assets have not been involved at all in the management or premises licence of this premises before. Your reference to the connection on Company House is that they've used the same address for their companies, which is not uncommon for a postal address to have many different companies registered to it, and that isn't evidence of a link between the two. And I can assure you that Mr. Ware has not been involved in the management of these premises before the 4th of July.
Well, excuse me, but that wasn't the question. I said, were you aware of any connection? And there is a connection because Wellington RITS Limited, RITS is rather an unusual term to affix to a company title, and there is a direct connection between Mr. Thomas Ware and Restaurants in Touch Southsea Limited, which is one of Mr. Ware's companies. There does seem to be a direct connection here, which goes back 2 years. This premises next door has been managed, or shall we say the controlling interest is with Mr. Ware or with Wellington RITS Limited, which appears. I mean, if you do a search on Companies House, there's a string of them, and they're all connected. And the poor management of the premises, this seems to me like just a simple extension of the original license holder, having gone into receivership, forfeited the license, and then wants to start up again, presumably carrying on the same management structure. And the premises supervisor was Mrs. Jane Elliott, according to this. I mean, I don't know how she fits into all this, but this isn't, shall I say, this isn't transparent. And this is my concern. This is the reason I wanted this to be brought up to this committee, because I wanted as many people to know what is going on here as possible. It needed to be a public meeting. This isn't transparent.
Just in answer, there wasn't a question there. It was just a statement.
Yeah, I know.
And I did answer the previous question, which was.
No, my question.
Would you let me speak, please? Your previous question was there a connection between Mr. Ware and the previous premises licence holder?
That wasn't my question. My question was, are you aware of any connection? I'm not asking you if you think there is. Are you aware of any connection?
The answer to the question is there is no connection between Mr. Ware or his company.
Sorry, that wasn't the question. Are you aware?
Well, you've entirely lost me, because if I'm saying there's no connection, how can I be aware of the connection if there is no connection?
Sorry, you're being evasive. You must be aware. I mean, have there been previous consultations between you and your client over other premises and this particular premises, this particular application?
I'm only dealing with the application for the Wellington. The point was raised about the ownership by the licensing officer having had conversations with you, and I took instructions on that. And as I've said, there is no connection between Mr. Ware, his company, or the previous premises licence holder. If there was a connection between the two and they were operating together, why on earth would Mr. Ware allow the licence to lapse and then have a substantial period where he's not been able to trade the premises? If he was running these premises, he would simply have transferred the licence to one of his trading companies, knowing that Miss Lum's company was going into administration. So that there's no sense to what you say in that Mr. Ware was connected with the management of the premises. He had the long lease of the premises and sublet them. So there is no interest in terms of managing the premises or having anything to do with the premises licence previously.
I'm sorry, but I didn't say managing. I said controlling interest. And presumably this licence lapsed when the company went into liquidation. That's Wellington RITS Limited, went into liquidation on the 3rd of March. There was plenty of time. The lockdown happened on the 28th of March. There was plenty of time to reinstate this licence or reapply for a licence. I'm just wondering why. I mean, it could be pure oversight. It could be negligence. I don't know. But I'm afraid my question to you was, have you had previous negotiations with Mr. Ware or any of his companies regarding premises or license applications before this one? And are you absolutely saying that there is no connection between this current license application and the previous license holder?
So in answering the second point, yes, I am saying that. And answering the first point, I dealt with Mr. Ware's application for the licence for South Parade Pier.
I'm going to end this conversation here. At this point, I think we've gone over a lot of points. Ben, do you agree with me at this point?
Yes, and I think it's important for the subcommittee to understand that Mr. Walsgrove is not a witness before the subcommittee. He's a legal representative. He's not providing evidence to the subcommittee as a witness, and there really ought not to be cross-examination. I think between the parties, the residents feel that there is some connection, and it appears that there is some connection insofar as Mr. Ware had a leasehold, but what Mr. Walsgrove was telling the subcommittee was that there was no actual control over the premises at the relevant time, and therefore ought not to be considered a connection in terms of actual management or control or oversight of licensable activities at the premises. Mr. Walsgrove, is that how you see the situation?
That's exactly right, and in fact is the situation across hundreds of licensed premises in Portsmouth, where the ownership of the pub has nothing to do with the people that have the premises licence.
Yeah,
and
I mean, you see it with large chains, Chair, where the premises licences may be held for hundreds of premises, but that doesn't necessarily mean that the company is actually involved with the day-to-day running of the premises. You also have situations where you have shadow licences, where there may be 2 or more licences for the same premises, where a person may own the freehold or have some legal interest in the buildings per se in terms of the premises, and wish to protect their position in terms of safeguarding a premises license. That doesn't necessarily mean that they are then also concerned with the running of the premises on a day-to-day basis. They just have a separate legal interest that kind of floats above. So it's not an unusual situation, is what I'm saying to the residents, and I don't think the subcommittee should draw too much on the particular point that's being raised, but obviously it's a matter for you, members.
Thank you. Mr. Walsgrove has his hand raised. Did you just want to clarify a point?
Thank you. It was just to add, your legal advisor mentioned shadow licences, and in fact that is the position at South Parade Pier. So Mr. Ware applied for the new premises licence to get the premises up and running, and then he has sublet various units on South Parade Pier. So, for example, the Gaiety Bar is not managed or has anything to do with Mr. Ware. That is somebody else who holds the premises licence in their name. It's exactly that situation. So, in relation to the Gaiety Bar, whatever is happening at the Gaiety Bar in terms of its management and its premises licence, currently it has nothing to do with Mr. Ware, but he does have a shadow licence. So should that tenant become insolvent, the same situation we got at the Wellington would not arise, because he has that sort of licence where he can step in, but he did not have the shadow licence at the Wellington, and obviously in hindsight that's something that he should have done.
Thank you for that. I'm going to ask members if they have any questions, because I might have a question for the applicant, Mr. Hudson, at this point. Councillors, any questions for the applicant before I swiftly move on? No, thank you. Could I ask a question of Mr. Hudson? In your role as operations manager, are you DPS of this venue, and are you going to be managing like on a day-to-day basis, or are you managing multiple properties and there'll be a separate DPS or manager at the premises?
Yeah, there is a separate DPS. I oversee sort of 4 or 5 venues for Mr. Ware, but there is a very experienced DPS going in there by the name of Carl Inman, who's got over 20 odd years experience, including 10 years experience with Young's Brewers as an auditor and a sort of a troubleshooter to go around. He's a very mature gentleman, like I say, who's got vast experience in the catering trade and will be excellent in the venue.
I think that's it for questions of the applicant now. So now we'd move on to the other person's case. So we'll start in order that I've received things. So Mr. Dewhurst, I'd like you to talk about your representation that you've made. I need to reiterate the point that you can expand upon points that you've made, but you can't bring up new information because it's unfair to the applicant and the rest of us here. Please maybe keep it more brief, and we're welcome to ask some questions after that. I'll just find your, and I want to reiterate the point that we've received your representation, so we know what you've said in advance as well, but thank you.
Okay, I am going to make a quick, a statement. So first I'd like to say that I'm grateful to have the opportunity to put forward my representation. A key point I'd like to emphasise is that the Wellington pub is situated in an unusually close proximity to the surrounding homes. Indeed, the pub garden, described by the pub as its hidden garden, is hemmed in all round by tightly packed residential buildings. Consequently, noise coming from the pub, and in particular its garden, very significantly affects those living in the homes around it. So in order to achieve a fair balance between the operation of the Wellington and the rights of the residents, it is especially important that the issue of noise should be fully understood and carefully addressed with appropriate conditions. This should do much to develop and maintain a good relationship between the Wellington and its neighbours, which we are keen to achieve. Now, I'd like to mention that we've made efforts to mediate. Following our written representation, there was an exchange of correspondence initiated by Mr. Walsgrove, in which he offered certain conditions, but omitting any reference to the all-important issue to us of closing times. We welcomed much of what he offered and agreed to his suggestion to have a discussion with Mr. Hudson, the bar manager, but in the event we heard nothing further until we followed up the matter with Mr. Walsgrove, only to be told that it was no longer possible to meet. We were prepared to continue efforts to mediate, but unfortunately the applicant was not. I'd like to now move on to the content of our representation. It covers 4 areas: the pub garden, the condenser unit, rubbish management and opening hours. So firstly, the pub garden. We welcome the fact that the applicant has agreed to the conditions stipulated by the EHO to close the garden at 10 p.m. However, we remain concerned about noise in the garden and feel there are further measures that can be taken. For example, a large canopy fitted by the previous licensee was removed. And we'd like to see something like this replaced, as it really helped to reduce noise. Secondly, the condenser unit. Again, we welcome the fact that the applicant has agreed to the conditions stipulated by the EHO to limit noise to 50 decibels at source. Thirdly, rubbish management. Okay, we've talked about this a lot already, but we were very happy with the fact that the applicant had offered some conditions, which were that all waste should be properly presented and placed out for collection no earlier than the night before the scheduled collection time, and that any waste bags shall be placed out for collection no earlier than 1 hour before the scheduled collection time. However, we would like to see more conditions added. That empty bins shall be removed from the street on the day they are emptied. And finally, that the pavement shall be kept clean and tidy at all times in respect of waste from the Wellington. As documented in my representation, rubbish has been a constant problem in the past and indeed recently. We believe that observance of these 4 conditions will ensure that the street is kept clean and tidy and more attractive to all concerned, including people using the pub. The 4th category in my representation was opening times. The proposed pub opening hours until 12:30 a.m. Monday to Thursday, 1:30 a.m. Friday and Saturday, and midnight Sunday do not satisfactorily take into account the unique location of the pub, its garden, and the close proximity to a high concentration of over 30 residential dwellings. These include families with young children and elderly people. Opening until 1:30 a.m. at weekends is not in line with the vast majority of other pubs in the immediate area, and by any standards, it's very late. Staying open so late is likely to attract customers from other local pubs that have already closed for the night, and the later a pub stays open, the greater the noise problem becomes. And it's unfair to local residents, especially young children and older people, to be subjected to this. John Walsgrove has stated that anything relating to the old licensee or license is no longer applicable. The old license is dead, and it's not a case of simply rolling over the old opening times into this new one. This is the time for us to actually be able to talk about it, and we urge the committee to bring closing time forward by at least 1 hour across the week. That's 12:30 Monday to Thursday, 11:30 Monday to Thursday, 12:30 Friday and Saturday, and 11 o'clock Sunday. We feel these would be fair and reasonable timings, and I hope that it can be taken on board by the committee. I'd like to also refer to the Licensing Act, which clearly states that the licensing authority should focus on the effect of licensable activities at the specific premises on persons living in the area around the premises, which may be disproportionate and unreasonable. It is our submission that the matters which we have raised, noise nuisance in connection with the very late opening times, noise emanating from the garden, and inadequate control of refuse are all matters which have a disproportionate and unreasonable effect on persons living in the area, and that appropriate conditions such as we have proposed should be stipulated to avoid this. Thanks for taking the time to listen.
Thank you very much for that. So, members, do you have any questions on reflection of that?
Only to ask, you talk about 30 residential properties. Do you know if they're like-minded? Have you spoken with them? Is your representation in some way respecting their views as well?
Well, in as much
Ben's put his hand up, sorry.
Just to clarify, we ought not to be sort of delving into that territory, unfortunately. Written representations have been received from those parties that are here today, and they're really the only ones that can actually make any representations to the subcommittee. So it wouldn't be admissible even if you went down that path.
Thank you. Sorry.
Any other questions, Councillor Ashmore? No? You can shake your head, I can see you on the screen, it's fine, you don't have to unmute. Mr Walsgrove or Mr Hudson, do you have any questions of this representation?
No, thank you, Chair.
Right, thank you. We'll go on next to, where's my list? Mr Owens.
Thank you. My representation was very short and concerned only with the rubbish outside the pub. I've listened carefully. In fact, I had a sight of the proposals that Mr Dewhurst was going to make before this meeting regarding conditions for refuse. They seem very sensible to me. Two of them are what the applicant had suggested in the first place. The other two just take it a little bit further and can hardly be regarded as onerous in any way at all for a manager who is running the pub in a proper manner. So I would associate myself totally with that proposal for the conditions regarding refuse. Thank you very much.
Thank you. Members, questions? No? Mr Walsgrove?
No, thank you, Chair.
Okay, then next up, please, Mr Spraggs.
Good morning. I've lived in Battery Row for 27 years with my family. I was born and educated in Portsmouth and love my city. Over recent months, my family have noticed changes going on with our neighbour. Wellington Public House, we feel that the pub is no longer supporting the 4 licensing objectives. I must tell you, I don't enjoy making complaints, but I hope you'll consider some of the difficulties we endure and offer some solutions. An example recently was Saturday the 18th of July. Music began playing at around 6 p.m. The volume was turned up to the point where we could hear it throughout our home. This home was originally built in 1754. There is no cavity in the wall, and so the sound penetrates very easily. At the same time, customers were singing along in the courtyard. While this seems fine, and so on, COVID-19 guidelines state, of course, that loud music and singing should be discouraged. This wasn't being done. I tried to phone the pub twice. The phone was not answered, probably because staff simply couldn't hear the phone ringing. I reported this to PCC's Environmental Health, and then Mr. Thorne, of course, called me to say that they had been trading without an alcohol license for many months. A week later, on the 24th of July, my partner was working late and she heard voices in the pub's rear garden. As the pub was meant to be officially closed for being unlicensed, Anita looked to see who was making the noise. There was a group of 3 people, 2 women and a man, drinking and smoking in the courtyard. Also visible, 2 other men in the pub. The time was about 1 a.m. The man in the courtyard returned their glasses to the bar and rejoined his friends at a balloon from which he started inhaling. Presumably that was nitrous, who knows? But we even have a photograph of a discarded balloon in the morning. Due to the noisy group in the rear courtyard, my partner closed all the windows to the rear of the house, and in doing so, she just couldn't help seeing that there was a light on in the Wellington, which certainly wasn't normal at this time of night. When she witnessed 2 men cutting up lines of white powder and snorting them from a stainless steel worktop in the kitchen. I went to witness what was going on. My partner took a live photo with her phone, which logs the time as 1:41 a.m. on the 25th of July. And it shows quite clearly one of the men leaning into the kitchen stainless steel work surface with a black straw in his hand, and then rubbing excess powder off the work surface as he leans back. The quality of this photo is pretty good, not terrific, but it shows some movement, and I think we all know what was going on there. The time was 2:22 a.m. Also possible was I have another photograph which proves that the lights in the bar were still on at 2:22 and so on. We were disturbed again at 2:30 a.m. as the music in the pub was put on very loudly and was turned off some minutes later. I tried phoning 101, and PCC's Environmental Health message to the Environmental Health Department was about 2:50 a.m. We went on to log the incident with the police website at 3:30 a.m. and we heard an unidentified male neighbour shouting to the group, "Shut the F up, it's 3:30 a.m. The people in the rear courtyard disappeared into the pub. For the benefit of the committee, when you enter the Wellington Public House, there are 2 doors. One leads to the pub's B&B rooms and the other leads to the pub bar. Presumably these doors have different locks for security reasons. It follows that one of the group of the 5 people at the rear courtyard on the night of the 24th, 25th would have been a key holder at the pub. This illustrates a total disregard of the licensing objectives and the lack of respect for neighbours. I know my evidence doesn't meet the required beyond all reasonable doubt, but it does meet the balance of probability that the event took place. The men in the kitchen weren't cooking, and they had no right to be there as members of the public. If they were, you say there was a member of staff, However, they certainly weren't cooking or working. When the pub, and this is all when the pub was officially closed. Moving on to another subject, the Council's Environmental Health Department have years' worth of complaints about cooking smells from the Wellington. In 2007, an engineer identified the current extractor system as not fit for purpose. PCC has also said that the unit has no planning consent, so it is illegal. The Council's environmental health team have recently recorded the smells as the worst they have ever smelt in the city. So why is this piece of equipment still in use and not condemned? We are simply unable to vent our home when the kitchen is cooking. I would therefore welcome definitive action about the system, because clean air surely is not an optional policy objective. It's a fundamental human right. I know that the Council have written to object to a possible extension on the top of Fontenoy House, a block of flats behind the Wellington, because of the potential loss of amenity to future occupants on the terrace over 20 metres away from the Wellington's illegal extraction system. But the windows of my home are only 3 to 4 metres away from the extraction system, and ironically, the Wellington's B&B bedroom windows are even closer. In terms of new restrictions on the Wellington's alcohol licence, I'm aware that the Council has asked for action on the pub's loud condenser, and they have negotiated a 10 p.m. curfew on the use of the rear backyard. And I thank Mr. Thorne of PCC's Environmental Health for this. I also note that the applicant has kindly made an offer through his solicitor to allow me to repair my house wall that the previous Wellington landlady damaged and refused to allow me access to make necessary repairs. While I welcome this offer, I would have preferred to have been present. I would have preferred not to be present today to describe the recent events at the Wellington. In 27 years, I've witnessed various managers trying to expand the Wellington into something it's not. It is a small, traditional, local pub in a densely developed part of Old Portsmouth. It should be restored to this to achieve some balance between the pub and the local community. And I know this has already been discussed. Regarding to the use of drugs in the Wellington's kitchen, I'm aware that drugs are everywhere in the city, and it's a never-ending struggle for authorities to stop them. Therefore, a reduction in operating hours of the pub seems reasonable, because with or without an alcohol licence, the applicant has demonstrated they cannot control the pub, and the Wellington's very late night opening hours have been abused. To reduce the Wellington's opening hours to being in line with other pubs in the vicinity would go some way to stopping a repeat of the night of the 24th and 25th of July. Due to the extreme closeness of neighbours to the pub and due to the age and fabric of some of the buildings, I would ask also that no music to be played in the rear garden, and for music in the pub to be played at a reasonable volume. In Portsmouth, space is at a premium, therefore relative peace is also at a premium, especially due to lockdown. Thank you for giving me the opportunity to speaking today.
Thank you very much, Mr. Spraggs. Members, do you have any questions?
I haven't got a question, but can I get some clarification from Ben, please, following on from something that Mr. Spraggs has said? That's all right. Regarding the illegal, so-called illegal extraction fan there, in what regards is it said to be illegal? Is it that it didn't have planning permission, or is it?
I think that's the assertion of the residents, is it didn't have planning permission and therefore it's unlawful. That's not something that this subcommittee can look into or make any decision on, or bear in mind when making your decision. I probably ought to take this opportunity to advise the subcommittee on a point that Mr. Walsgrove has earlier addressed about the cooking fumes situation. I have considered the point quite carefully, and I do agree with his take on the law insofar as cooking at the premises, given that they're not undertaking late night refreshment and therefore there's no licensable activity taking place, and could, as he states, could take place irrespective of any grant of a license today. And therefore I would say that the cooking, smells and extractor fan issue ought not to be taken into consideration when you're making your determination today. However, he has mentioned, and it is quite right, that statutory nuisance can include odour. So Environmental Health do have powers under the Environmental Protection Act to pursue the matter if it does continue to cause a nuisance. Obviously, if the public house were to start to wish to provide food after 11 p.m. at night, that then does become a licensable activity and then would fall within the remit of the subcommittee or the licensing authority to control if necessary.
Okay, so we can't decide on that here about the extraction fan, but residents have got action they can take through environmental health measures if they so wish.
Indeed, my understanding is that the applicant is actually now engaging in meaningful, ongoing discussion with Environmental Health and the residents to try and resolve the matter, and that's how it ought to be resolved, not by any form of decision today, unfortunately.
Okay, thank you.
Chair, I see there are a couple of residents' hands. Mr. Dewhurst.
Sorry, I was speaking and obviously didn't hear it. I was saying, Mr. Dewhurst, I see that your hand is raised. Would you like to just quickly say something?
Yeah, only that in the licensing authority clearly state that when considering a license, that if there is any issues caused by noise or smell, that this should be taken into consideration when deciding on a license. So it clearly states in the Licensing Act that smell has to be part of the problem. So why in this case?
It's not in this case because it's not a licensable activity in this instance. As I said, it can be if food, hot food, so food above ambient room temperature is served after 11 o'clock at night, it then at that stage becomes a licensable activity and requires a license, and therefore falls within consideration of the Licensing Act. If it's before 11 o'clock at night, it's not licensable, and there is no regulation through the Act. So the subcommittee has no power to consider or impose any particular conditions or restrictions.
Mr. Spraggs.
Yes, thank you, Chair. I just wanted to say that we understand that it is an illegal build, but it was never built adequately anyway. It's not tall enough. The top of the chimney actually spews out fumes only on our second to third floor, and we go to 5 floors here. And that's really what I'm saying.
Sorry, I might make a point that this is mainly for planning enforcement and not for licensing, I'm afraid. I would urge you to contact them if you think this is the case, and they will be probably best to advise. Isn't that right, Ben?
Yeah, absolutely. And also just to reiterate that it simply isn't something that the subcommittee can consider today. If the pub were to be granted a license and in some point in the future decided that it wanted to serve food after 11 p.m, then it would have to apply for a variation to its license, and it could be addressed at that point in time. But at this stage, it's not something that the subcommittee has any power to consider.
Okay, well, thank you very much.
I've got a raised hand. I've got Mr. Yates to speak next anyway. So, sorry, was it Mr. Owens wanted to say something there? Someone's got a hand up on my screen. No, not Mr. Owens. Mr. Spraggs. I'm losing names. I apologize. Just as Anthony, I'm afraid. Just as Anthony, not your full name there. So.
Yeah, sorry. Yeah, regarding licensable smells, does that include cigarette smoke? Because the cigarette smoke does occur.
Yes, I don't think cigarette smoke has been raised in any written representation. Do correct me if I'm wrong.
I did raise it.
You did. Okay.
Yes.
Fair enough. Because the cigarette smoke is so closely linked to the consumption of alcohol, there is a very clear nexus between one and the other. It does more generally fall within consideration of the licensing committee, so conditions could be imposed in relation to smoking if that were deemed to be necessary and proportionate.
Thank you.
Representations. Have we just left with Mr. Yates? Is that correct? I was working through the list alphabetically after everyone started talking to throw me. So, Mr. Yates, would you like to present your representation?
Right, I'll keep it brief. I'll try.
Thank you.
And I won't get emotional. I was born in Portsmouth from a naval family. I've been here for 62 years. I moved to Battery Row about 15 years ago. And I'm immensely proud of our city. And I'm also immensely proud of what the City Council have done in Old Portsmouth. When I moved here 15 years ago, Old Portsmouth was a bit run down with the odd bus depot and so on. And Portsmouth City Council have spent millions of pounds down here getting it right. And it does attract the tourists, and it attracts visitors from all over the country as well. And as I say, I'm immensely proud. But over the past couple of years, I've become very aware of the deterioration of the conduct of patrons, the cleanliness and the disturbances caused by the management or as a result of the lack of management at the Wellington. And this is why I was making the point earlier about the continuity of old management and new management. Mr. Atwell's points being noted, of course. Now, my email of the 11th of July 2020 makes it clear about the unacceptable way in which some of the patrons of the pub have behaved. I've had my house urinated on from people from the pub, and I know it's from the pub because I've returned the beer glasses. I've picked up beer glasses from outside of the pub. I've picked up beer glasses from the ornamental trees outside Mr. Dewhurst's house and returned them to the pub. I've walked past the pavement, and the pavement has been absolutely festooned with cigarette ends. And the pavement is also stained with spilt beer and whatever else comes out of a bottle. This happened, of course, before lockdown. Now, like the other members here, I've got one window at the rear of my property, and I rely on this to ensure that fresh air blows through the house. When I have this window open and the pub is trading, my house is filled with the noxious cooking smells from the pub. And the layout of the buildings nearby form an enclosed quadrangle. The fumes from the pub's ventilation system discharge into this space, and this seriously impacts on the air quality, and something should be done about it or stop it altogether. The pub garden also, as I mentioned earlier, the pub garden also causes problems from the often raucous jeering and raised voices, the drifting cigarette smoke and the continual drone of the ventilation appliances. I have to shut the windows to get any chance of getting any sleep. All the problems I've mentioned will be exacerbated by the fact that TW Assets have applied to reinstate the licence. And this allows for licensable activities until 1 o'clock, with the closing, obviously, or throw-out time at 1:30. I feel it's inappropriate given the total residential, I feel that it's inappropriate given the totally residential location of this pub and the confined position of the pub garden to allow this licence to be just simply reinstated as stands. If anything, the use of the pub garden should be further restricted. And thank you for listening to me today. Thank you.
Thank you very much. Members, do you have any questions arising from that? No, I can't see you, Dave. No, thank you. Mr. Walsgrove, do you have any questions at all? Mr. Hudson?
No, thank you, Chair.
Right then, I don't think I have any questions. I have a question of Derek Stone, if possible, coming in before we start summing up. A late question, I do apologise. Derek, pubs in the vicinity, like the Dolphin and stuff, quite close, or even is it the Buckingham down the road, the ones who've been serving all that food during lockdown? Could you tell me what their licences are for booze, please?
I can. Do you want me to go through all of them, or the ones?
Yeah, basically all in the vicinity of. I just want to know times.
Okay, so Duke of Buckingham.
Yeah.
They open from 10 till 00:30 in the morning. Alcohol up till midnight.
Yeah. Is that Monday to Sunday?
Yes. Yeah, all week. Yeah. Dolphin. On a Sunday, they serve alcohol from 12 to 23:30. On Monday to Saturday, they can do alcohol up to midnight. And Monday to Saturday, they shut at half midnight or 00:30. Sallyport, Monday to Sunday, they can do alcohol from 10 o'clock to 00:30. Monk's Bar, they can do alcohol from 10 till midnight, open till 00:30. And then you've got a couple of other places that you don't really need to know about, like the Co-op and the Good Fortune. The Bridge Tavern is probably your latest, or one of the latest. So it's just around the corner. They can open till 1:30 in the morning, serving alcohol on a Friday and Saturday up to 1 o'clock. And that's similar to Spice Island. Spice Island, they have a slight variation. So between May and September, 1st of May and September, the hours are longer. But they, in effect, can go till Friday and Saturday. They can do alcohol up to midnight, closing 00:30. Still and West, alcohol Sunday to Thursday from 10 o'clock to midnight, and then on a Friday and Saturday up until 1 o'clock. So that's probably the main pubs in the area. So some do have hours of operating and trading after midnight.
Thank you for that. I didn't know you could variate like just for months. I learn something new every day, and there you go. I think we're moving close towards a summing up now. Members, is there any questions that you need to ask of anyone before I move to summing up? No? Cool. Let's do this then. So we will so those who have made a representation, is there anything you would like to add at all? If you've already mentioned it, don't mention it again. Just wave your hand, because I can pretty much. Mr. Dewhurst, I've got a hand. Thank you.
Yeah, I'd just like to state that with the licensing hours, obviously, if you're looking at, for example, the Bridge Tavern or the other two that are at the end of Spice Island, obviously they're in a completely different location. They're not surrounded tightly by residential buildings. They face outwards onto open spaces, and they're the only ones with the later licenses. So it's worth just bearing that in mind. You know, this pub is in a completely different location, tightly packed by all residential buildings. That's all I'd like to say on that one.
Thank you for that. Mr. Yates.
Yeah, and on that point, if the other pubs in the area, like the Still and West and the Bridge Tavern, turn out earlier than the Wellington is due to close, what's to stop everybody turning up at the Wellington to finish off their evening's drinking if the Wellington's hours extend beyond those of the other local pubs?
Thank you. I'll keep that in mind when we make our decision in a bit. In that case, I will move on to Mr. Walsgrove. Is there anything you'd like to add? And it goes the same for you, Mr. Hudson, if you'd like to sum up, please.
Yeah, I'll just briefly sum up and pick up on that last point about the hours. The premise is the Wellington has had those hours for the last 15 years, and if there'd have been any evidence of late night revellers coming from other bars to the Wellington, then those would have been included in the residents' representations and evidence given. But what they've said is there is a likelihood that that may happen. They haven't said that it has happened in the past. And so it isn't the case that such a small venue as the Wellington, and you've seen and heard, in fact, from a local resident, that it is a small traditional English pub, is not going to be attracting drinkers late at night. It hasn't done in the past. It didn't do under the temporary event notices that the new operators have had, and it wouldn't happen in the future. So you do have to consider the nature and character of the premises. In relation to the history, as I've said, this is a new management, despite what has been said. It is under new ownership and new management, and with the conditions that have been offered, none of the responsible authorities have raised any other concerns, and it's their view which I ask the committee to attach the greatest weight to. Obviously, we're here as the applicants, and we're bound to put our best foot forward and tell you everything's going to be fine, and likewise the residents, in protecting their interests, are going to raise issues of concern. But what the responsible authorities do is in effect sit in the middle and provide an objective analysis using their expertise, and the conditions that agreed are the ones which we say are the only ones which are appropriate and can be added to the premises licence should you grant it. So finally, the issue of being able to raise a review, the residents can raise a review at any time, and there has been one back in 2009 where I understand.
Did it just disappear? Did that just happen? Is that a yes, Mr. Walsgrove's disappeared? Because I can't hear him.
Am I back again?
Yeah.
Yes.
How much did you hear and not hear?
Only about 5 seconds worth. I guess you saw everyone's face at the same time.
Oh, no. I apologise. I'll try to speak quicker then to cut it down even more. The point I was making right at the beginning of my summing up was that the premises has had the hours that it's applied for the last 15 years, and all the other local pubs have had their late night hours. If there was a scenario where people were going to search out the Wellington for a late night drink, it would have happened already, and residents would be able to adduce evidence that it has happened in the past, that there are late night issues with people coming to the Wellington later in the evening. What they've all said is that it could happen. It's likely it might happen. Well, it hasn't happened. Not when the licence was in place, and not when the temporary event notices have been used in the last couple of months. I stress that it is under new management. I know the point's been raised that it's not, but it absolutely is. And the reassurances given in relation to the food smells, which, as your legal advisor has said, isn't relevant to you today. My client understands the importance of that and is in discussion with environmental health. So please don't think that because you don't get to make a decision on it, that it's not something which is being acted upon by my clients. It is. And likewise, the conditions agreed, we say, are the most appropriate. In relation to waste management, we did offer conditions to the residents with a view to avoiding a hearing. As it went to a hearing, none of them withdrew. It's a matter for you whether you think conditions are appropriate to deal with the waste issue. It's within your discretion. It's not a case of offering conditions. You've heard the evidence. You'll make your own decision on that. And lastly, the point about the review. It is a very important point to make, because that's when the government brought the Licensing Act in, that's why they said a light touch could be applied to businesses, licensed premises, because it's a quick and easy process to bring a review. And the residents have heard the assurances given today. They will know what conditions, if you grant the licence, are on the licence, and it wouldn't be difficult for the matter to come back to a committee in a short period of time, within it's 28-day consultation with a hearing a couple of weeks after. So within 6 weeks of any issues arising, the matter could be back before you. So it puts my client on trust. So all the things they said they're going to do and how they're going to manage it, we're giving you those assurances. And the purpose of the review is to make sure they stick to that good management of the premises. So attach all the weight, I would say, to the fact the responsible authorities have assessed this application objectively. They have proposed conditions which the client has agreed to, and we say the licence can be granted for the hours and with those conditions and no more. And we'd like to take the opportunity, obviously, to thank the committee for their time and also to reassure the residents that although no meeting took place before this hearing, given that hearing was already fixed and the timescales involved, that Mr Hudson is more than happy to meet and discuss any of the issues following this meeting, particularly in relation to the issue of the condenser and the food smells, which are ongoing matters with environmental health. So thank you, councillors.
Thank you very much. So I've had a hand from Mr Spraggs.
Yes, thank you, Chair. I just wanted to say I don't agree with Mr Walsgrove.
Unfortunately, I cannot take that anymore because we're on summing up, and I did give everyone an opportunity to speak
Yeah, but as a result of his last...
I can't allow discussion after he's summed up, I'm afraid, because we're all finishing now. Obviously, there was opportunity to present during the meeting, and I do apologise for that. But honestly, everything that you have said during this meeting will be taken into consideration when we make our decision. I assure you of that. Mr Hudson, did you want to add to that, or are you happy just keeping Mr Walsgrove with what he said? Cool, I can see you shaking it. Mr Stone, would you like to sum up?
I have nothing further to add. You'd be pleased to know.
Okay, then I've got the final bit of my script here. I'd honestly like to thank everyone for coming along today. This concludes our formal meeting. What happened now is the members of the committee, along with the legal advisor, will now meet for their deliberations on a separate Microsoft Teams chat, and we'll make our decision. And the decision will be sent in writing to all parties today, if at all possible. I imagine it'll be by the end of play today. It's 12:05 members. I'd really like to make a hot drink and have a comfort break. So shall we say 12:15, 12:20 to come back to deliberate on the next meeting? Yeah. Cool. Thank you. Thank you very much, everyone. And sorry, Anna.
Yeah, I was just going to say, I'll stop the live stream now, shall I?
Yeah, it's all done. Thank you very much.
Well, I can't do that now.
Thanks once again, everyone, for turning up.
Thank you.
Have a nice afternoon.
Thank you, everyone. Thank you.
See you later. Bye-bye.
Bye.
Well, it came to a